The law allows you to disregard his testimony from the witness stand if you don't find it credible.
We don't trust him.
The law allows you to consider as the actual, real evidence his actions at the time of the murder if you don't find him credible. Intent to commit a crime. Well, ladies and gentlemen, you got to find that they intended to commit these crimes, and how do you look at that? Well, you look at the natural and necessary consequences of the act, right? Natural and necessary consequences of an act. Deadly force is the last resort. Never point a gun at someone you do not intend to shoot. So when you start pointing a shotgun directly at somebody, what's your intention? The natural and necessary consequence of the act, you're going to kill this person. You're pointing it at him. The defendant's not going to be presumed to have acted with criminal intent, but you may find intention, or the absence of intention, upon consideration of their words, their conduct. What did they do out there? Their demeanor, their motive, and other circumstances. So when you look at each defendant separately, because that's what you're going to do, you're going to get 3 separate verdict forms. When you look at Mr. Bryan, what were his words? What was his conduct? What's his motive? What were the circumstances there for Mr. Bryan? What were they for Greg McMichael? What were they for Travis McMichael? All right, so what we're going to do now is we're going to talk about the charges in the indictment. All right? I'm going to make a suggestion to you. This may help you. Start at the bottom of the indictment. All right? In your deliberations, start with criminal attempt and false imprisonment. It's just easier. You just work through that one, work your way on up, then to felony murder, then to malice murder. It's a suggestion. So what have we got? Criminal attempt to commit a felony, which is false imprisonment. What's an attempt? That's when you perform an act which constitutes a substantial step toward the commission of said crime. Mr. Bryan pulled out of his driveway and ran him into a ditch. Mr. Arbery was able to keep running. Right there, criminal attempt to commit false imprisonment. Criminal attempt to commit false imprisonment. This is actually what it says in the indictment. What do you have? In violation of the personal liberty of Mr. Arbery. Okay? Guess what? We're citizens of the United States, right? We live here. We have personal liberty because this is a free country. Other people can't go up and stop us and hold us and detain us. Okay? They have to actually have seen us commit that crime in order to effectuate a citizen's arrest. So you go around and you start stopping people, you're doing that in violation of their personal liberty. And what did they do? They unlawfully chased Ahmaud Arbery through the public streets of Satilla Shores in pickup trucks and did attempt to detain and confine him without legal authority on Burford using an F-150 pickup truck and a Chevy Silverado pickup truck. We all know that's what they did. False imprisonment. Now this is over on Holmes. In violation of the personal liberty of Ahmaud Arbery, did unlawfully confine and detain Ahmaud Arbery without legal authority. Once again, did not see him commit any crime, not a citizen's arrest. They are not law enforcement officers. They are not in a marked patrol car. They are not with badges on their arms. They're not in any uniform. Without legal authority. Said accused did chase Ahmaud Arbery with an F-150 pickup truck and a Chevy Silverado pickup truck through the public roadways of the Satilla Shores neighborhood and did confine and detain him on Holmes. Travis McMichael said he was pinned between the 2 trucks. Greg McMichael said he was trapped like a rat between the 2 trucks. The ultimate false imprisonment, he never left Holmes, did he? Never left Holmes. Aggravated assault, did make an assault upon the person of Ahmaud Arbery with a Ford 150 pickup truck and a Chevy Silverado pickup truck. I got a legal note here for you. Okay, you notice how it says and. Okay, but what do we know? Mr. Bryan's driving the Silverado. Travis is driving the Ford F-150. Greg McMichael is in the passenger seat at first. Then he's in the back of the truck. So, of course, it doesn't mean and, it's or. Okay, I know that sounds crazy. Don't you love lawyers? Don't you just love lawyers? Okay, and means or. So the way you should read this is with a Ford F-150 pickup truck or a Chevy Silverado pickup truck. Okay? So, what are pickup trucks? They are objects when used offensively against someone can result in serious bodily injury or death. You hit somebody with the F-150 pickup truck intentionally? You hit them with a Silverado intentionally? Are you going to hurt them? Break a leg? Paralyze them? You could even kill them. We all know that. Hit and runs, right? Vehicle homicides. We all know this. And the medical examiner told you so. Actual injury to Ahmaud need not be shown for aggravated assault with the pickup trucks. The judge is going to instruct you. You don't have to actually hit the person. You don't actually have to injure them for it to be aggravated assault. What you have to do is place that person in reasonable fear of receiving a violent injury. This is really important, ladies and gentlemen. Did the defendants commit acts with their pickup trucks that placed Ahmaud Arbery in reasonable fear of receiving serious bodily injury? Yeah. Yes, they did. We know Mr. Bryan did. He ran him into a ditch, then tried to go at him again, then went at him another time, then backed up toward him. Now, what did Travis McMichael get on the stand and say? Oh, I just pulled up next to him. No, I didn't startle him. No, he wasn't afraid of me. Do you believe any of that stuff? Just look at the Night Owl video. Look at how Mr. Arbery tries to get away from them, and then look at them speed off after him. So all you have to do is look at that Night Owl video, and you'll know that they put him in reasonable fear of receiving bodily harm, violent injury, aggravated assault with the pickup trucks. Aggravated assault in count 6. Did make an assault upon the person of Ahmaud Arbery with a firearm, a deadly weapon, that 12-gauge pump shotgun with 7 already in it. 2 steps, pull the trigger. That's all you gotta do. The evidence is that the defendants attempted to cause a violent injury to the alleged victim by shooting him. Yeah, that's aggravated assault with a shotgun. Now, I want to be really clear, okay? Travis McMichael does this with the shotgun. We see it on the video. This is the beginning of the aggravated assault. Beginning of the aggravated assault. The aggravated assault continues as he steps away from his car door and blocks the road. Now, what did he say to you? Oh, it's putting distance between me and Mr. Arbery. Was he putting distance, or was he blocking the road? You decide. Then what does he do? He doesn't stay right there, does he? We can't see this, but what do we know? He makes it around that car door, right? He makes it over here, right? He's in front of his truck, and he's moving forward, closing the distance on Mr. Arbery, intercepting Mr. Arbery, and is right here with that shotgun. It wasn't at port arms like this. It was right like this. And how fast does Mr. Arbery come around the corner? And boom, shoots him. That is one continuous aggravated assault ending in the shotgun blast to his torso, right here. Came out right here. Right? So how was he when the shotgun hit him? Like this. Right? Got it across the wrist, got it right in the torso, came out right here. So he's turned like this, according to the medical examiner. Felony murder. Felony murder is when you commit a felony and someone dies because of the felony. Classic felony murder scenario. Guy goes into a convenience store to rob the convenience store. He's not there to murder anybody. He's not there to kill the clerk. He doesn't know the clerk. But he's got a gun, right? So what does he do? Pulls out the gun and is pointing it at the clerk. And the clerk's like, and what does the clerk do? The clerk goes and tries to hit the gun away and starts punching at the armed robber, right? And then what does the armed robber do? Boom! Kills the clerk. Was committing a felony. You cannot claim self-defense. You've now murdered the clerk because during the felony that you were doing, you pointed, you were doing armed robbery, you're pointing a gun at somebody. You expect when you're committing felonies, people are going to fight back, right? The convenience store clerk's entitled to fight back, right? Imagine if armed robbers could come in and go, well, I had to defend myself against the victim of my crime. Could you imagine if that was the law? Right? I mean, but isn't that what they're saying? How dare Mr. Arbery defend himself against their 4 felonies? Isn't that what they're saying to you? So felony murder, let's take a look at it. What is felony murder? For felony murder, the state must prove that the defendant caused the death of another, check, by committing a felony. Check, we got 4 of them. Do not need to show malice, okay, meaning intent to commit the death of somebody. You know, like the guy showed up at the convenience store, he's not there to murder the clerk. Do not need to show he intended the death with the felony. What we have to show is this, that the felony directly caused the death. You pull the trigger on the shotgun, aggravated assault with shotgun, yeah, immediately caused the death, right? That's a no-brainer. But what about the other 3? You're sitting there thinking, okay, Linda, what about the other 3? What are we really talking about here? Did the other 3 felonies, aggravated assault with the pickup trucks, false imprisonment, criminal attempted false imprisonment, did they play a substantial and necessary part in causing the death? The state's position is, yes, they did. In other words, but for this felony being committed, the death would not have occurred. It's real easy. But for the felony being committed, this death would not have occurred. All right, so when does this really apply? The defendants are in the process of committing a series of felonies. They're doing it together at the same time. The defendants shoot Mr. Arbery during the commission of the felonies. Did that felony committed against Mr. Arbery ultimately contribute and lead to his death? So how do we look at this? Aggravated assault with a shotgun? Yes. Pointing that shotgun at him, having him run away around the side of the car, Travis McMichael intercepting him with the shotgun and then shooting him? Definitely aggravated assault, felony murder. Aggravated assault with pickup trucks. Well, once again, what do we have? Would he be dead if he hadn't been pinned between these 2 pickup trucks? Think about this. If he'd made it up Holmes and over on Zellwood, he'd have run out, right? If he hadn't been pinned between the 2 pickup trucks on Holmes, with Mr. Bryan running him towards the white pickup truck, would he still be alive? Yeah. Their use of the pickup trucks to go ahead and commit aggravated assaults on him, put him in fear of them and their pickup trucks, meant he was running away from them. He saw it, running away. Did their actions, were they such that they put him in reasonable fear of receiving bodily injury? And did that contribute to him ending up where he ended up and his death? Yes, it did. Felony murder. False imprisonment on Holmes. That's what we're talking about. Did they falsely imprison him on Holmes? We've already gone over it. Had him pinned on Holmes, trapped like a rat between the 2 pickup trucks, according to Greg McMichael. He's still, after 5 minutes, running away from them. If they hadn't done this on Holmes, would he be alive? Ask yourselves that. If the answer is yes, felony murder. Check it off. Criminal attempted false imprisonment. So you're thinking, well, Linda, I mean, seriously, okay, that was over on Burford. I mean, yeah, they pulled up to him. Hey, stop, we want to talk to you. He runs away. They pull forward. They go down to the end of Burford. He then runs away from them again. They're trying to falsely imprison him over there. Did that contribute to it? Yes, because that's when they began their attack. They're using the pickup trucks over on Burford to put him in reasonable apprehension of receiving serious bodily harm. They're putting him in fear with their actions. What does Mr. Bryan do? Actually runs him into a ditch. Runs him into the ditch. Aggravated assault. So what's Mr. Arbery doing? We know he runs away from them, and runs away from them, and runs away from them. Because they have tried to falsely imprison him on Burford, and they've used these pickup trucks to do it in a manner that's likely to cause him fear. We don't know what was going through his head. Nobody knows. That would be speculation. But you're allowed to look at it and go, were their actions such that it would put a reasonable person in fear of getting hurt? That's what you want to ask yourself. Those are the felonies in the indictment. So malice murder. What's malice murder? Well, cause the death of another person unlawfully and with malice aforethought. Now, malice aforethought is not ill will or hatred. It's not like what we think of. No premeditation is required, okay? Rather, it's the unlawful intention to kill without justification. Okay? Well, what's justification? Justification is self-defense. Deliberate intention to kill is one way you see malice murder. I'm deliberately taking your life. I'm killing you. How do we usually think about that? You're out to get somebody. You want the husband murdered for the insurance money. You're going to go ahead and execute somebody. You're mad at somebody. You're enraged at somebody. You intend to kill them. That's deliberate intention, right? But there's another kind of malice, and that's implied malice. You are allowed to consider this when looking at malice. You may also find malice when there does not appear to be significant provocation and the circumstance of the killing shows an abandoned and malignant heart. Don't you love lawyers? What the heck is an abandoned and malignant heart, right? Well, think about that. You just don't care. You just don't care. What you're doing, you want to do what you want to do, and boy, whoever you're doing it to had better be okay with it. I'm going to order you to stop and talk to me. And if you don't, I'm going to pull out a shotgun on you. And hey, you're still going to run away from me? Oh yeah, I'm going to come at you. I'm going to intercept you over here at the corner. How dare you turn on me? Bam! Malice, right there. Remember, Mr. Arbery had to have engaged in significant provocation. What did he do? What did Mr. Arbery do? He ran away for 5 minutes. He ran away from them. Ran away from them for 5 minutes. That's what he did. With his hands out at his sides, and those baggy shorts he had on. No weapon, no threats, no way to call for help, didn't even have a cell phone on him. Ran away from him for 5 minutes. The state doesn't have to prove premeditation. The state does not have to prove motive. Okay? Not required to explain to you why they did what they did. You know what they did. Some of you may know why they did it. But the state does not have to prove exactly why they did what they did. The indictment. So here's the thing, party to a crime. How in the world could defendant Bryan be held responsible if he was in the Silverado filming all this, right? How can Gregory McMichael be held responsible if he's in the back of the truck, finally on the phone with 911 when the shots ring out? Well, it's called party to a crime. That's what it's called. So what's party to a crime? Well, ladies and gentlemen, let me ask you this. Do you think that everyone involved, from the person who actually commits the crime, to someone who encourages or enlists someone to commit the crime, to someone who helps commit the crime, should be held responsible under the law in Georgia? Do you think that sounds reasonable? Well, guess what? The law does. The law says everybody involved is guilty. Okay? A person is a party to a crime only if that person directly commits the offense. Driving the trucks, pulling out that shotgun, attempting to falsely imprison, helping to trap somebody by pinning them between two pickup trucks, running someone towards a man with a shotgun, all directly committing or helping in the commission of the crime, or advises and encourages. Well, what's advising and encouraging? Hey, Travis, get your shotgun. That guy is outside. Not, hey, Travis, I need to call 911. That guy is outside. Let's get our guns and let's jump in the truck. Encouraging. Advising. Cut him off, cut him off, cut him off, is what Greg McMichael said. So that's what we've got. Ladies and gentlemen, how do you really want to think about this? Everybody gets a Super Bowl ring, right? The quarterback gets a Super Bowl ring. The guys in the field get the Super Bowl ring. The dude on the bench gets a Super Bowl ring, right? Everybody is involved. Everybody's responsible. That's what the law says. Cooperation after the fact. Now this applies to the defendants, but mostly, kind of Mr. Bryan, because this has been brought up when he was talking to Agent Seacrest and everything. So, first off, cooperation after the fact doesn't erase the crime you committed. Bryan did film the murder on his phone. He gave the phone over in the video right away to the police. He made statements to the police at the scene, at Glenn County. He then goes and makes additional statements to the GBI in May of 2020. He consented to have his home night owl video downloaded. Guess what? Doesn't matter. Cooperation after the fact does not erase what you have done. Okay? That would be like two teenagers shoplifting at Walmart, and one's filming the other, he. Both of them are stuffing bikinis into their bag, right? The fact that one of them hands over her video of her girlfriend doing it, does that somehow make her not guilty of stuffing a bikini in her own bag? No. You still did the crime. So what if you were cooperative afterwards? Still are responsible for your actions. This is about responsibility. All right, we're going to transition right now. I'm going to take a breath. And we're going to transition into self-defense and citizen's arrest. How's my time? Person is justified in threatening or using force against another person when and to the extent that he reasonably believes that such threat or force is necessary to defend himself or a third person against the other's imminent use of unlawful force. Wow, that's a mouthful, right? Yikes. Okay, let's break it down. Travis McMichael had to reasonably believe that it was absolutely necessary to defend himself, and of course he threw in his dad, okay, which he never mentioned before at any point in time, but he threw him in on the stand, against the other's imminent use of unlawful force. That means Mr. Arbery had to be right there, imminently using unlawful force against Travis McMichael. Okay? It's the doctrine of reasonable beliefs, and the judge is going to go ahead and charge you on this. In other words, the belief that you have got to defend yourself, that it's life or death right here, right now, has to be reasonable. Okay? Guess who this standard applies to? Just take one guess who this standard applies to. Everybody. It applies to you. It applies to law enforcement. It applies to military people. Okay? It applies to Jason Bourne, Secret Service, CIA, FBI. It applies to everybody. There is no special exception for I was in the Coast Guard. There is no special exception for I used to be a law enforcement officer. The reasonableness applies to retired law enforcement officers just like it applies to anybody. A manager of a store, okay, applies the same way. In other words, the reasonableness standard is set by society. You all decide whether this was reasonable or not. Travis McMichael's belief that he had to defend himself with lethal force has to be reasonable. So we got pointing a shotgun at Mr. Arbery when he's yards and yards away, had to be reasonable and necessary. But where's the imminent use of unlawful force by Mr. Arbery? What was he doing? He's running away from Mr. Bryan's truck. Mr. Bryan has already tried to hit him with the truck numerous times. He's trapped between two cars with no weapon. No way for anyone to help him because there's nobody out there to help him. He's not threatening anybody. He's just running away from the man with the shotgun. Look at this. I mean, take a look at this. He's not even up to those mailboxes on the side. And that's Travis McMichael pulling that shotgun up. Well, what are they going to tell you? They're going to tell you what Travis said. Oh, he was running toward me. And I could tell he was going to attack me. Is that reasonable? Who brought the shotgun to the party? Who took the shotgun out of the car? Who pointed the shotgun? The guy's running away from them for 5 minutes. Here's the thing, you cannot create the danger to yourself. That means you cannot be the initial unjustified aggressor. You can't create the situation and then go, I was defending myself. You just can't do it. He moved to intercept. He attacked him. I'm not talking about Mr. Arbery attacking Travis. All right, here's the concept of excessive force. And this is a big one, because here's the thing. If you use excessive force during your self-defense, guess what? You're not justified, you're guilty. Not justified, you're guilty if you use excessive force. Because it's force that exceeded what was reasonably necessary. You guys ever heard the term that's saying, you can't bring a gun to a knife fight? It's unfair, right? You can't bring a gun to a fist fight. It's unfair, right? You can't use excessive force. You can't call someone out and go, hey buddy, let's take it outside. You're starting it. And then when that person starts to beat you up and is better at the fight than you don't get to pull out a gun and shoot them. You started it, you called them out, they're better at this than you, and all of a sudden, you're like, I'm scared, I have to defend myself. That's not the way this works. Excessive force. So first off, Ahmaud had to be using unlawful force against them. Remember the guy running down the street, right here? He's using excessive force, he's using unlawful force against them right here, right? Then, Travis McMichael had to reasonably believe that he had to defend himself against Mr. Arbery. And they're going to get up here, and the thing is, ladies and gentlemen, they're good. These defense attorneys are good. They're going to get up here, and they're going to make it perfectly, they're going to make this seem like, oh yeah, this is scary. And Travis had to pull a shotgun out on him. They're going to make it seem so reasonable. Put on your critical thinking caps. Use your common sense when they're up here giving their closing arguments. The amount of force has to be reasonable. Unarmed man running with hands at the sides, never pulled out a weapon, never threatened anybody. This is completely excessive force. Even if you think, ladies and gentlemen, even if you go, hey, it was citizen's arrest, hey, he was really defending himself, you then still have to go, this wasn't excessive force, in order to find them not guilty. All right? What you didn't hear from the defense in their opening statement are the 3 instances when a person can't claim self-defense under the law in Georgia. Can't be the initial unjustified aggressor. This is important. You can't start it with your driveway decision, unjustified, because you didn't see a crime committed that day, and then claim, oh, I acted in self-defense. What's their justification? What are you going to hear? We wanted Ahmaud Arbery to stop and talk to us, and he wouldn't. So we tried to force him to stop, and then we killed him. I mean, that's really what they're going to get up here and tell you. They'll probably make it seem much more palatable and okay, but that's really what they're going to tell you. You can't commit felonies against someone and then claim self-defense. You can't be the armed robber in the convenience store pointing the gun, and when the clerk goes to defend himself by grabbing that gun or hitting the armed robber, you can't shoot him. The law goes not self-defense when you're committing felonies against someone. And you can't provoke someone into defending themselves against you so that you can intentionally harm them and then claim self-defense. Okay, what's that about, ladies and gentlemen? Think of your schoolyard bullies. Think of the 3 boys walking behind the one who's the target, kid who's getting abused, right? Okay, so you got 3 on 1, they're going down the hallway, they're menacing him, maybe threatening him, and they get him up against a locker, and he has nowhere to go. He's trapped, right? So what does the kid who's being bullied do? He takes it and he takes it and takes it until he can't anymore, and he finally shoves the one bully, and what does that bully do? Bam! Punches the target child, right? What's the bully always say? He started it. Isn't that what the bully always says? He pushed me. I was defending myself. Yeah, 3 on 1 with one kid up against a locker. You're bullying him. And he actually pushes you, and you get to then claim you were acting in self-defense when you punch him? Guess what? The law knows people do this. I mean, you get this. This is the law. The law knows people will goad other people into defending themselves so that they can claim, I was acting in self-defense. You can't do that either. 3 on 1, 2 pickup trucks, 2 guns, unarmed. Mr. Arbery was unarmed. So what are you going to hear? I don't know what they're going to say. They're good. They're good defense attorneys. They're going to get up here, and the state is so worried that they're going to make it seem so reasonable, that everything that Travis did and Greg did is just so reasonable. I'm just going to ask you, use your common sense and put your thinking caps on. But this is what I anticipate, what we anticipate they're going to say. The victim started it, or you're going to hear that he was the aggressor, okay, because he was running towards Travis McMichael, but he was running away from Mr. Bryan, who'd already tried to hit him with the pickup truck. And Gregory McMichael said it. He was trapped like a rat. He knew there was nowhere else to go. You know? Or they're going to tell you that, ladies and gentlemen, this is really about the front of the pickup truck. Forget everything else. It was all about the front of the pickup truck. And they're going to try and make it seem like, well, he attacked Travis McMichael. He very well might have. We can't see. What we know is his hand was like this, right? Doesn't matter. You know why it doesn't matter? Because they weren't committing a citizen's arrest. They weren't in fear, real fear, of imminent danger from Mr. Arbery. They were committing the 4 felonies. That's what they were doing. You're going to hear, we weren't committing felonies, we were doing a citizen's arrest, we weren't trying to provoke him into defending himself. You're probably going to hear this. Yes, we pointed a shotgun at him to get him to comply with our orders. Not sure why anyone should comply with their orders, to stop and talk to us, but there was no reason for him to defend himself against us, because this was a citizen's arrest. Ladies and gentlemen, this is the bottom line. As I said in opening, I'm going to say it to you again. This was an attack on Ahmaud Arbery. They committed the crimes. They committed the 4 felonies. They attacked him. They shot and killed him. They can't claim self-defense under the law because they were the initial unjustified aggressors and they started this. And they were committing the felonies against Ahmaud Arbery. They have to somehow justify their actions by claiming citizen's arrest. I'm going to remind you once again, evidence from the witness stand, they never, ever said on February 23rd, 2020, that they were doing a citizen's arrest or trying to arrest him. It was all, we wanted to stop, we wanted to question him about what he was doing because he must have committed a crime that day, and we were going to hold him so the police could go back and figure out what crime it was that he must have committed because he was running down the street. Citizen's arrest. If the offense is committed in his presence or within his immediate knowledge. If the offense is a felony and the offender is escaping, a private person may arrest him. So what are they going to do? They're going to do this. Oh, I'm sorry. I forgot to tell you this. A private person may not act on the unsupported statements of others alone for their probable cause. What does that mean? No gossip. No hearsay. Nothing along those lines. In other words, my mom told me about this, where she has no personal knowledge of it, doesn't count. That's unsupported, unreliable statements of somebody else. You have to have more than stale information from an unreliable source. A private citizen's warrantless arrest must occur immediately after the offense, or in the case of felonies, during the escape. If the observer fails to make the arrest immediately after the commission of the offense or during escape in the case, his power to do so is extinguished. Okay, what does that really mean? A citizen's arrest is for emergency situations when the crime really happens right in front of you and you can take action right then and there to arrest somebody because you know about it. You've seen it. You're taking action right then and there. If it's a felony, you can run after the person and chase him down. That's all this means. So it's not a citizen's arrest. They never said it. None of the defendants saw Mr. Arbery commit any crime that day. They were detaining him for the police so that they could investigate and find the crime that he must have committed that day because what is he? He's running down the street. That's not the law, ladies and gentlemen. not the law at all. Travis McMichael, remember all his assumptions? He got up here, and I wrote them all down. He may have run by. Matt Albenzi may have seen him. He may have broken in. Maybe the owner's down there. He may have been caught. He may be trying to avoid the police. That's testimony from the witness stand. He didn't know anything. Absolutely nothing. So where are we going to end up? This is where we're going to end up. Travis McMichael had probable cause to believe that Ahmaud stole the stuff off the English boat in 2019 because his mother gave him some gossip about stuff being stolen, and he was escaping. Use your common sense. How do you escape from a crime on an unknown date in 2019 on February 23rd, 2020? I'm sure they'll explain it to you. But use your common sense. And remember,